access denied. Hello, and welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people. People who had quite the eventful day today, post-Thanksgiving. I hope y'all had a wonderful, wonderful celebration. If you celebrate, and for those of you who don't, I hope it was a very happy Thirsty Thursday, and you got in on some of those Black Friday deals. So, alas, we are just people, though. We continue to forge ahead, right? No matter what, no matter how many hours of recovery you needed from yesterday's festivities, because we have opinions about all things going on in the true crime community, including this update in true Beverly cannoli oil fashion, coming in hot with this denial of the Commonwealth's request for records from Verizon Wireless for not just Janet Reed, but Bill Reed as well, too. Now, I have, obviously, Janet Reed's motion from the Commonwealth to access the Verizon Wireless records up for you here, but they essentially both say the same thing. And I was actually talking about this earlier with our friends from the Andrew Myers channel. We are going to be talking about this even more in depth in his upcoming episode on Sunday morning. So stay on the lookout from that. I will be sharing a link to that video as soon as it goes live, so you can tune in there. Pretty much what she just says here is denied despite the detailed, it looks like derailed the way that she wrote the T in there. When I was first reading it, the derailed arguments, detailed arguments articulated in the supporting memoranda, and oral arguments, the affidavit in support of the, it's so hard to read her handwriting, of the motion is insufficient. It fails to meet the requirements of Lampron. So signed, Beverly Cannoli Oil. And this is huge. This is very, very huge. Of course, she had to come in Friday afternoon, right? She wanted to make sure she had a freed up weekend so she can enjoy her Black Friday early bird Christmas shopping. But this is big. This is pretty big news for Team Karen Reed because, you know, in true Beverly cannoli oil fashion, she generally rules against anything that has to do with favoring Karen Reed and her defense. So I don't know if this was her way of throwing a bone or if it was just because the argument that Hank Brennan presented at the hearing the other day was insufficient and lackluster in itself.
I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone...
I mean, but didn't in the motion there was like a typo of, hey, I want all of his records since 2002. So, I mean, would you be agreeable then? Like...
phone calls at 1:30 in the morning. I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impact.
Ah, yes, Dr. Hank Brennan now. I mean, yeah, I'm sure that John O'Keefe could very much still be alive and well if he never even walked inside of 34 Fairview to begin with. I actually believe that, and we wouldn't be where we are today if he hadn't just gone into that house. Now, nevertheless, what you're failing to acknowledge is the fact that there is a first responder right upstairs. And several guests who were in the home that night as well, too, who saw Officer John O'Keefe, they did, no matter what they want to tell you, they saw him, and they walked past him. The big black blob, right? Walked right past him. So his whole purpose for this is because he's trying to, in my opinion, skirt away from the using or having to use the Bermuda Triangle sisters, right? The Sullivan sisters, and that that is a remarkable theory that you guys cooked up with, right? The fact that Karen was just so angry over this trip, so angry that she just had to hit him going 24 miles an hour in reverse in a blizzard. Yes, it makes so much sense. She was just waiting for that opportunity, the weather to hit just a certain degree and for the flurries to start fluttering down at a certain pace. So before she made her big moves, like that was the driving force. So I feel like with them trying to do this, they're attempting to do a few things. One, and a lot of people have said this too, and I definitely agree with this, they want to keep Bill Reed and Janet Reed out of the courtroom, right? If they're witnesses in the case, witnesses related to the defendant, they can't be in the courtroom. That happened in the Ashley Benefield case, which was so sad. Her mom got called up, and then she wasn't able to sit in for the rest of the trial, which is just so heartbreaking because it's like your daughter is literally on trial for unaliving someone and is facing some serious time. This might be the last time, or one of the last times, that you get to see her. And you can't even, like, show your support for your daughter because Hank the Tank wants all your call records to anybody who you've ever called or contacted within that 30-day period of when Officer John O'Keefe was unalived, and 30 days prior to that, to see if there's a pattern, right? A pattern of whether or not Karen has a good relationship with her parents. And, like, look, everybody's relationships with parents are different. I don't call my parents all the time. I just called them yesterday because it was Thanksgiving. Like, we do not have a very close relationship. But I know a lot of people who do. My wife being one of them. Her and her parents call each other every freaking day. And sometimes multiple times a day. Whether it's good news, bad news, or they're just catching up. Just for the sake of catching up. And I would infer, my inference would be that, yeah, if I was in the same situation as Karen Reed, right, where, you know, I'm super pent up, I'm angry about, you know, all the fighting, it's all been building up for weeks and weeks and weeks, months and months and months, and this is just further demonstrating why she didn't trust John O'Keefe. She didn't. It was pretty clear from the text message exchange they had all throughout that day that she didn't really have a whole lot of trust in him, in his fidelity. So, him not giving the old head nod for her to come on into 34 Fairview, and essentially at that point she's saying, wow, he just ditched me for his friends, for all these women who's texting him all the time, Jen McCabe, right? His ex lives like a few houses down or something. He's not answering her calls, her texts, even though he said he would give her the signal to come on in. She's pissed. She has to go to the bathroom, right? She goes back to his place, taking care of the kids, playing babysitter once again. Then it's 1:30, and she doesn't know what she wants to do. She doesn't know. Should I stay? Should I go? Should I go and, like, look for? I don't know, like, where the heck he is. Like, what do I do in that situation? And I could totally see myself maybe not calling my parents. I'd probably call my sister. If she didn't answer, I probably would call my parents and anybody I knew. I'd probably call my wife's parents. I'd probably call everybody. My parents included, no matter how close or not close I am. So I feel like this is like a huge jump. And I know why he's pivoting towards this strategy, because it's, I guess, a little bit more believable than the whole Aruba sister, Bermuda Triangle sisters theory about John being a cheater, pumpkin eater. So, and we know how this ends now because of what we learned in the beginning of this video, but it is interesting to hear his argument for it and how if only Karen made that 1:30 a.m. call to the 911 and the Canton police, John O'Keefe would still be alive today. And for that, I think if he never entered 34 Fairview, he just went back home with Karen, he would still be alive today. Whether or not they'd be together is a different story, and that doesn't even matter, but
impairment. But I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial.
Yeah, meaning her boyfriend's car. So, I mean, I don't know, and I'm gonna skip a little bit ahead in a few minutes, but I also kind of see this again in like reprocessing this information as the Commonwealth trying to establish a little bit more of a timeline as well too, because the timeline in the first trial was all over the place. I mean, it started out with Karen Reed hit John O'Keefe at 12:45 a.m. and then it dropped down because she connected to John O'Keefe's Wi-Fi network at 12:36 a.m. and they were like, there's no way that's possible, and they left the waterfall at this point of the night, so at like 12:11, and then they got there, she waited in the car for a few minutes, and then they were like, oh, well, she must have hit him like pretty much upon arriving at 34 Fairview and leaving the scene immediately, and then somehow magically pulling up to John O'Keefe's house within like a 4-minute drive, even though I think when we looked at it, it's at least like an 8 to like 12-minute drive without traffic and not in the snow, right? I mean, yeah, could she have been hitting the gas a little bit harder that night? Probably. You know, your angry emotions are flurrying up like all the snow that we kept hearing about in trial 1. But still, you're driving in snow. It's dark. Even if she did drive a little fast. And I'm sure that's something that they could have pulled as well, too. Information. How quickly was she driving after she left 34 Fairview? I'm fairly certain you would be able to pull that information. So I feel like this is kind of, and also an attempt to establish a little bit more of a timeline between when she had hit him and then when she arrived, at like 6 in the morning, and found Officer John O'Keefe on the ground.
The time of the phone calls to Miss Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, "In your first discussions," my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it will be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny.
I like the nod. Like, it's little things like this that you don't always pick up right away. I mean, Turtle Boy wears his heart on his sleeve. Like, you can tell exactly what he's thinking as you're watching this. But he's seated directly behind Bill Reed. Bill Reed gives a head nod. He's like, "Go ahead, confront me. I have nothing to hide. Call me as a witness, bro. I will bring the freaking heat, but can you take it, my guy? Can you take it, Hank the Tank?" I don't think so.
His daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show...
So he's essentially insinuating that Janet Reed could have been in possession of his phone. And it's like, how would you even know that? There's no way to prove who was holding the phone, who was operating the phone, who was making texts, who's making calls. And they probably also have their own phones too. Now, yeah, sometimes when I'm stepping away from something to do something, I might hand my phone off to my wife, and that's fine, that's normal, but there's no way to prove that. And like, why does it matter? When they start talking about the Boston Magazine article and the Fox 25 interview as well too, and with the Reeds and what's been redacted, and Karen made an interesting statement about that. About the fact that if there was an alleged confession such as this, which he is inferring about, then why would Ted Daniel not lean into that? Like, that would be a huge, like, piece of the story to say, yeah, Karen confessed to a few people. And we have the story. We're breaking news. You know, like, how much that would catapult his career even more? This is one of the biggest cases that is being covered of this century. And if they are all sitting on these alleged confessions that Karen allegedly made, either on the record or off the record, why are none of them breaking their silence about it? Why are none of them breaking that story? Break that story and you might actually change my mind. But it didn't happen.
Different communications. Sometimes calls or hang-ups don't register on a phone. And so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team. And the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But
after Proctor was already found his set of nudes he was looking for. So.
I do know is we cannot say that the records from Ms. Reed are a full accounting of her records. And so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Like, part of me too is like, why didn't he just have Lally argue it? Because, like, Lally, like, knows more about all of this stuff, all of the pre-trial hearings from the first round. And I get, like, you're the one who crafted the motion, you're the new boss in town, right? So you gotta take the podium, Hank. But I just feel like, in terms of just understanding what they have and, like, letting Lally argue this, maybe throw the guy a bone, I don't know. Like, poor guy looked so miserable at this hearing the other day, and, like, it kind of pulled a little bit on my sympathy strings in the fact that he's been deduced. Like, he is pretty much wearing a dunce cap, metaphorically speaking. So poor guy.
Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied.
Denied. And it was denied, so very good job. She did an excellent job arguing this the other day.
The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy, so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is, that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's. And he wasn't present at the Waterfall on January 29, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone.
That is an excellent point, because she was so fast to throw the book down from them wanting to see, Brian Higgins. His records, right? His phone records. Brian Alberts. Literally anybody who was a witness there at that party, very quick to throw the book down on that.
Using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night.
Mm-hmm.
The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all 4 elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that 4-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization...
Other than his inference. And before we continue, I just want to play that clip of Bill Reed, because that has, like, circulated around a lot. But I think it's important just to give us a little bit of context, because we never covered it here on Alexasrewm. So this is from a month ago from Boston 25, when the motion was initially filed, but this is the clip in question.
Filing, prosecutors want all the footage 25 Investigates shot that day and any notes from the interview. The filing says, statements made by the defendant to William Reed regarding the timing of the damage to her taillight is extremely relevant and material evidence that will be introduced at trial. This section of the interview is mentioned in the filing. During your first discussions with Karen, did she believe she may have hit John?
No. She felt she struck something. She said, Dad, I think I struck something. I said, what do you mean? Right? This was in the hospital. Right? He says, I remember, all right, backing up and hitting something.
Bill Reed also said what his daughter struck was John O'Keefe's SUV, hours after prosecutors say she hit O'Keefe outside 34 Fairview Road around 12:30 a.m. on January 29th, 2022.
And that's how that vehicle was damaged.
The filing says Bill Reed's first discussions with his daughter took place by phone at 6:32 that morning, when his daughter was transported from 34 Fairview Road to the Brockton Hospital for a mental health evaluation. Not at the hospital, where they met up in person. In a separate motion, the DA's office is seeking Bill Reed's phone records from the morning of John O'Keefe's death and the month before. A lawyer for Boston 25 says the station has yet to receive any notification about the filing from the DA's office or the court. Neither Karen Reed's lawyers nor Special Prosecutor Hank Brennan immediately responded to messages. For 25 Investigates, I'm Ted Daniel.
Yeah. And that was a whole other thing, too, that Beverly Cannoli Oil was like, oh, did you notify, like, the third parties? And he's like, no, I didn't notify because I didn't know if this was even going to be allowed. Like, this is something that I could actually do. It was such a weird, like, response. And it's like, dude, if you're filing a motion, like, you have to notify people. Like, it's just so sneaky and snaky. And... again, I don't know tons about Hank Brennan. I don't want to believe that he's, as somebody anti-government corruption and handling a lot of cases in that regard. I just think it's so ironic, and I want to think that he's not sneaky, and maybe, I don't know, maybe that was Lally's job, and Lally's like, I'm sorry, I didn't notify them.
The organization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, I believe I hit something, was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning.
And I like that little, the flub over there, Eliza. That was funny.
The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon.
Exactly.
The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th.
Exactly, and it's like if all you're looking to see is like how often Karen Reed calls her parents, then you can again see that from her call records. Like, it makes no sense. And like, what would be the purpose of wanting access to a cell phone if you weren't looking for something a little bit more interesting than call log records? But again, that's my opinion.
Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29th, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed calls her father cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m., after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't.
And something else, too, that makes zero sense, right? Because if we're looking at this, like, going back to the timeline thing, right? If we're going to go with the idea that she allegedly hit John O'Keefe sometime between, 12:30, or, like, let's even broaden the window a little more, like 12:20 something and 12:45, and then realizes, oh, I think, like, when was the moment when she realized, oh, I think I hit something, aka my boyfriend, oh well, let me just go back to his house. And then within that 1 to 2 hour window that Hank Brennan had mentioned earlier about how life-saving measures could have been taken and he could still be alive today via drilling a hole in his brain, like, what a weird way to present that argument, by the way, but I digress. Then you're essentially saying that Officer John O'Keefe would have been dead within that, 2 hour Like, am I understanding that inference? Am I inferring correctly? Like, he would have been dead well before Jen McCabe, Kerry Roberts, and Karen Reed all rolled up and found him? Because that makes no sense, because he was still alive when Karen Reed got there. So, again, it still doesn't make any sense for me what the possible purpose would be in trying to get Bill Reed's phone call records.
Asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Bang, bang is what I call that. And I love how they zoom in on Bill Reed's face here. I mean, it's a beautiful day in the neighborhood, right? If you are in the camp of Karen Reed is innocent, which if you watch these videos, I'm sure you are. Now, in other news, before we wrap this shindig up, Turtle Boy dropped a interesting update. So there was an update regarding our favorite meatball, that crafty meatball, Meatball Morrissey. So Turtle Boy did a public records request for all of Meatball's emails sent to public officials using his burner iCloud account. They withheld embarrassing emails. He used this account regularly to email dozens of judges about court business. He even mocked the trial courts, which you're going to see in a second, and their efficiency in one email. The last email we received was September 29th, 2023 email that we know exists, in which he demanded that Judge O'Malley do more to protect witnesses like Chris Albert, which we went over. They want us to believe that he just stopped using that account altogether after regularly using it since 2020. So really, really interesting. And this is the email that he is referring to. Good news. I'm not sure who's more screwed up, the vaccine program or the trial courts. Hope all is well. Michael. Sent from my iPad. So he's also using it on multiple devices, which I'm also very curious about too. Like, how many devices does he have, personal, work-wise? Courts have looked to three factors to assess the weight of the privacy interest at stake. 1, whether disclosure would result in personal embarrassment to an individual of normal sensibilities. So yeah, this I guess is in response to... Yeah, this is in response to his public records request. I guess they just got this today. And then 2, whether the material sought contain intimate details of a highly personal nature. Like, what if anything would that be? I'm very curious. And 3, whether the same information is available from other sources. So I'm sure there's going to be an article all about that, and when there is, we will be talking about it here on Alexasrewm. Note that Turtle Boy does have a hearing coming up on Monday. We will definitely be covering that here on Alexasrewm. Now, before we go, to end on a high note, since, it's Black Friday, and I saw this going around, and I thought it was really nice. And I wanted to share it with y'all because it's important. Karen needs our support more than ever. And if you can, either make a donation or share this with somebody, share it with friends, and or both, that'd be great. So if you can make a donation, you can scan this little QR code at the bottom here with your cellular device. Don't worry, We're not going to sick Hank Brennan on you to, track all of your data from 30 days ago. Don't worry, your phone records are safe with us here on this channel. But if you want to make a donation, you can do so there, or again, share it with some friends and fam who are able to as well. So that being said, thank you so much for watching. If you enjoyed today's content /news, make sure you hit that notification bell, make sure you hit that subscribe button, and make sure you hit the like button, because that tells the YouTube algorithm that this is newsworthy news, and it is. It's a beautiful day in the neighborhood, and we should celebrate the fact that Beverly Cannoli Oil finally did something right. Will she continue to do more things right? Who the heck knows? But nevertheless, I will be here with you every step of the way. I will see you in the next one.